This week, the Health Secretary, Shona Robison, announced a review into the so-called unnecessary deaths of 6 babies at Crosshouse Hospital in Kilmarnock. Speaking in the Scottish Parliament, the SNP MSP Kenneth Gibson has called for the inquiry to be wider and deeper and to include a review of Health Board's legal responses to grieving parents. Later that night on BBC Scotland 2016, Mr Gibson told our colleague Graham Stewart about the profoundly distressing circumstances in which he and his wife Patricia lost their baby 7 years ago.
Well, what actually happened some 7 years ago was that my wife on her due date went into hospital. She was then sent home, was violently sick, went back to the hospital. After about 45 minutes of arguing, they finally agreed to admit her. She was put into a ward where I wasn't permitted to join her, given morphine and left overnight, and when she awoke in the morning, the baby had died. Now, she had pain from head to toe. Her entire body was in great agony, and despite the fact that a consultant, 2 midwives and a junior doctor examined her, they didn't notice that she was suffering from preeclampsia. After the baby died, they tried to have her deliver the baby naturally, but her liver ruptured, so she had a C-section and she was in intensive care and high dependency for 19 days after that. And that was just really the kind of beginning, if you like, of the appalling experience that we went through. Because from our perspective, all we wanted after the event was not to blame anyone, but just to find out, as many parents do, what actually happened, and to have an explanation from the Health Board as to what they would do to ensure that what happened to us did not happen to anyone else.
And how long did it take to get a satisfactory answer?
Our baby died in October 2009, and we finally settled with the Health Board about 6 months ago, so about more than 6.5 years. After 20 months of being blanked by the Greater Glasgow Health Board, we had no option but to take legal action to get some kind of a response from them, and that's when the legal machine of the Health Board went into overdrive. They hired an expensive QC and made it as difficult as possible for us to pursue what was frankly an open and shut case, as it turned out in the end. And I do think it's appalling the way grieving parents are treated, and I just wonder how many other people frankly are in the same position. I think it's shameful that instead of facing up to their responsibilities and just explaining to people what they're going to do to improve things, health boards seem to do all they can to try and bury their heads in the sand.
Yeah.
I felt constrained as an MSP. I didn't want anyone to think I was seeking preferential treatment. So I wrote to no ministers. I did not write to Health Board as an MSP, but as a member of the public. But I'm pretty sure that many people are utterly ground down. I mean, people are grieving. People have lost their babies, which are very precious. And this is not about compensation. What you actually get in Scotland for the death of a baby at stillbirth is about 3% of what Charlotte Church allegedly got for having her telephone hacked. Legally, babies in this country when stillborn are worth, frankly, nothing except to their parents, to whom, of course, they're absolutely priceless. And it's really time that the Scottish Government stopped this heavy-handed approach from health boards.
That's the SNP MSP Kenneth Gibson. Well, in a statement, Greater Glasgow Health Board said, "We can confirm an out-of-court settlement was reached in this case, but it would not be appropriate to comment in detail." Joining us now is Lindsay Bruce of Thompsons Solicitors, who's a lot of experience in representing members of the public in actions against public bodies. Good morning to you, Lindsay. Thank you for coming in. In your experience, is there too often a response from health boards or councils that's overly adversarial and heavy-handed?
Oh, absolutely. It's a situation where you find it time and time again that they don't want to engage in any kind of pragmatic or transparent way, and it often is just a shutdown and very tough approach that they take, which I understand claims have to be investigated, they have to be looked at, absolutely, but there could be a much more pragmatic and transparent approach to dealing with situations that are often very horrific in their circumstances for those involved.
And Lindsay, what is the cost of that, both in terms to the people, the human beings involved in the process, but also to the public purse?
It's a lot of money, and it's exhausting for those that are involved. as a lawyer myself, I find dealing with the emotions that come from my clients, just the sheer energy that they have to put in is almost more than that they have left to grieve, if it's that type of situation, and it's just exhausting, and it's years. It's not a simple process. It takes a lot of time and energy from them to come to meetings, to engage in processes, to attend court hearings, and that on top of what's happened to them is absolutely tiring.
And of course, the health board lawyers, the council lawyers, the other public bodies lawyers, they're paid for by the taxpayers, and often they're instructing expensive legal counsel, QCs, all the rest of it.
Absolutely. I mean, if we just take the example of equal pay in Scotland, it took 10 years for what was very low settlements in the end, in some cases, where they took a very aggressive approach. They hired commercial law firms in some instances. So the women were effectively paying tax to then have to that tax money be used to a commercial law firm to then basically they're fighting themselves to a certain extent.
And Lindsay, how much are we seeing what they call the court step settlements, where everything's taken right up to the appearance in court, and a practice that was found so offensive with, in the mesothelioma cases, where people were looking for compensation from insurance companies, and this was seen as reprehensible. But is this what's happening sometimes with public bodies?
It is, but it is reducing. There's a number of court reforms that are coming in that will hopefully reduce that, but it is it's still a position that is adopted, unfortunately.
I suppose from, for example, health board's point of view, they've got professionals working in a field in life and death situations, and it is a matter of fact that sometimes nobody's to blame, that tragedies actually happen, and what they want to avoid for their professional teams, who could also be profoundly distressed by what happened, is a witch hunt, as it were. Where does the balance lie, do you think? Should there be more arbitration? What should happen? Because Kenneth Gibson repeatedly has made the point, they just wanted an explanation. They didn't want to blame anyone. They just wanted an apology and an explanation.
That's what I see all the time. They just want the answers. They just want to find out what went wrong, and they want to stop it happening to someone else because they don't want to see someone else be in the position they've been in. And they definitely need more pragmatic approaches like arbitration or out-of-court meetings where families get a chance to ask their questions without it having to be a fatal accident or having to be court process or having to be something that's very legalistic.
What do you make of the Apologies Scotland Act, which I think came in at the beginning of this year, which is essentially, it'll be civil legal proceedings obviously, but it's essentially a without prejudice response where health boards or councils can say, I'm sorry this happened, but, as I say, without prejudice?
I think it's a step in the right direction. I think it's a good thing to see that there's a different viewpoint being adopted and considered. I think more of that needs to be done.
But just to summarise here, the people that you're dealing with are in, as we're saying, absolutely profound distress and despair. They're exhausted, they're emotionally exhausted, and emotional exhaustion is physically exhausting. And that's the point at which then, when they go to public bodies and say, please explain what happened here, and please apologise, please make sure it doesn't happen again, it's your experience that the response to that is, we will fight you legally every line of the way here, and just hopefully, in their minds, grind you down to the point where you've no energy left to pursue this.
That's often the case, that the clients that I represent just get exhausted and feel that they can't continue and that it shouldn't be this much of a fight just to find out what went wrong and what happened with whatever civic body that you're dealing with. And I think, that I don't know if it's a case of that the minds aren't applied soon enough to be able to resolve things, or if it's just the legal mechanism kicks in and then it is an adversarial system and there's no thought given to the individuals at the circumstance, and you're focused on the law, you're focused on, what regulations, is it time barred, you're focusing on all those kind of things, when actually the focus should be on what went wrong, how we can fix it and what shouldn't happen again, and giving the answers that the individual's looking for, which is it's not about compensation in most cases. It is about getting the answers and stopping it happening again. It's as simple as that. So from that point of view, I would say that I think once the legal machine kicks in, yes, you do get answers, but it can be very slow, and you do have to have that energy to fight through and use things like freedom of information and use things to try and get information, and going through the courts to get your documents. And it should be a wee bit easier to get your records and to get your information and to actually find out what went wrong, particularly if there's an adverse inference.
So you would welcome a review of all of this, as Kenny Gibson suggested?
Absolutely,
yeah. Okay.
Absolutely.
Lindsay Bruce, thank you very much indeed for that. Thank you.